Hello, class. Welcome to Connected. So, children, today's class is about judiciary. Before moving to our main topic, let's run through an introduction. One of the three branches of government is the judiciary. In our country, the union and the states are both served by a single integrated judicial system. The courts are responsible for interpreting and enforcing legislation passed by both the Union Parliament and the state legislatures. Moving on to our first and foremost topic for today's class, organization of judiciary system in India. The judicial system has been split into three levels. The Supreme Court is at the top, followed by the High Court, and the Sessions Court is at the bottom. As indicated in the chart, there are other courts, but they are not part of the hierarchy. The organization of India's judicial system is depicted in the diagram below. Moving on to our next topic, the Supreme Court. The Supreme Court is the highest court of appeals. According to the Constitution, the Supreme Court's decisions are binding on all courts within India's borders. The composition and appointments. The Supreme Court is made up of the Chief Justice of India and as many additional justices as the law allows. Originally, the Supreme Court was made up of one Chief Justice and 7 additional justices. The strength was raised in 1985. It presently has a Chief Justice and a maximum of 25 justices. Article 124 Part 2 of the Constitution states that the President may select Supreme Court judges as he sees fit. In this subject, the President will consult with other people in addition to the Prime Minister's Council of Ministers. The President shall consult such Supreme Court and High Court justices as he deems essential in the case of the Chief Justice of India. Appointment of judges. There are provisions in place for a High Court judge to be appointed as an ad hoc judge of the Supreme Court, as well as for retired Supreme Court or High Court judges to sit and function as judges of that court. Qualifications. A judge of the Supreme Court must meet the following requirements. A judge of the Supreme Court must be an Indian citizen. He must have at least 5 years' experience as a judge of a High Court or of one or more such courts in succession. He must have at least 10 years' experience as an advocate of a High Court or one or more such courts in succession. He must be, in the President's opinion, a distinguished individual. The introduction of the last clause allows the President to nominate a prominent Supreme Court jurist even if he did not meet the requirement of years of practice at the bar, was meant to broaden the pool of candidates. Tenure or removal. Once appointed, a judge serves until he reaches the age of 65. Only proven misconduct or incompetence can result in the Supreme Court judge being moved from his office. He can be removed from the office by an order of the President, which must be supported by a majority of the entire membership of each house, as well as a majority of not less than 2/3 of the members present and voting. Prohibition of practice after retirement. After retirement, a judge who has served on the Supreme Court is banned from pleading in any court within India's borders. However, there is no constitutional restrictions to the government appointing a retired judge to a specialized position, such as chairperson of a commission. Remuneration. Judges' salary are deducted from the consolidated fund of India's budget. In addition, each judge is entitled to a free house as well as a number of additional benefits and privileges. Immunities. To protect judges from political disputes, the Constitution provides them with protection from criticism of judgments and actions taken in their official position. The court has the authority to bring contempt changes and charges against anyone who accuses judges of having ulterior motivations while performing their official responsibilities, even if the Parliament is unable to examine the judge's actions until a resolution calling for his removal is on the table. Seat of the Supreme Court. The Supreme Court is normally seated in Delhi, although it may convene at other locations as the Chief Justices of India with the consent of President may determine from time to time. Moving on to our next topic, the state judiciary. The High Court. In our unified judiciary, each partner or combination of states and union territories has a High Court in place. Article 214. For Punjab and Haryana, there is a single court in Chandigarh. Similarly, in the case of Assam, Meghalaya, Manipur, Tripura, and Nagaland, there is one court in Guwahati. Delhi is the only territory in the union has the High Court separately. Composition. The Constitution stipulates that for each state there is a High Court. Each High Court consists of one Chief Justice and additional justices whom the chairman may think is essential to designate from time to time. In conjunction with the Chief Justice of India and the governor of that state, the President shall be nominated to the High Tribunal. The President shall nominate other justices of the High Court. The Chief Justice of the High Court is also consulted in addition to the Chief Justice of India and the governor. Appointment of additional acting or retired judges. If necessary, the President may appoint more judges. If the post of the Chief Justice is vacant, the President may designate an acting Chief Justice. At all times, the President's Chief Justice of the High Court may seek the retired High Court judge to sit and serve as a judge, with the prior approval of the President. Transfer of a judge from one High Court to another. The provisions of Article 222, Part 1 allow a judgment from one High Court to be transferred to another High Court following consultation from the Chief Justice of India. Qualifications and tenure of the judges. Appointing as a judge of the High Court is qualified as 1. An Indian citizen, 2. A judicial officer at least 10 years long, or a High Court advocate in any state of at least 10 years. A High Court judge's retirement age was before 60 years, but currently, according to Article 217, is 62 years, Clause 1. A judge has a right to pension and other benefits following his retirement. A judge of the High Court may also voluntarily retire or be removed from the office. As noted above, the procedure for the removal of a judge from the High Court is similar to that of the Supreme Court. Now children, we will study about the powers and jurisdiction of High Court. We will begin our topic with original. Only when courts which are subordinate to the state High Court are not competent, not legally permitted, to resolve such issues in the absence of monetary and territorial jurisdictions, shall their original civil and criminal jurisdiction be exercised by the High Court. In some situations, the High Court may also have original jurisdiction if it is designated specifically in the territory of the state or union. Example, cases under the company law are only brought before the High Court. In the case of civil proceedings involving the value or property of Rs 1 lakh and more, the Delhi High Court shall entertain their original powers. Similarly, in the case of Parsi weddings, the Bombay High Court has an original competence. With jurisdiction, Article 226 states that the High Court of 15 is the protector of fundamental rights. Any citizen may submit in a High Court a letter requesting his or her rights to be enforced. In order to preserve its right, the court issues a letter, order. Writings are frequently released demanding that government authorities do specific actions or that they withdraw from certain actions in order to safeguard individuals' fundamental rights. The original competence of the High Courts is the competence of the writing. Appellate jurisdiction. In essence, the High Court is an appeal tribunal. It is competent to appeal inferior tribunals. An accused verdict of an inferior tribunal in that state might be reduced or even acquitted by a High Court. Control over subordinate courts. The activity of tribunals within the jurisdiction is monitored by the High Courts. The High Court therefore has authority over the district courts and those beneath them, according to Article 235. Moving on to our next topic, subordinate judiciary. Children, pay attention to this part because it's a vital part of this chapter. There are a number of judicial courts administrating justice in each state outside the High Court. These courts are fully controlled and supervised by the High Court. In order to set the constituent organization and territorial jurisdiction of all courts subordinate to the High Court, a state has exclusive legislative authority. There are many sorts of subordinate or lower courts in each district of India. They are civil, criminal, and income tribunals. These courts are responsible for civil, criminal, and income law cases. Civil courts. The District Judge Court is the highest civil court for civil proceedings in a district. Very commonly, when dealing with both civil and criminal issues at the district level, the same court is termed the District and Meeting Judge. The governor of the state shall appoint the judge of this court. There may be one or several subjugal courts in the district below the court of district judge. Subjudge courts have been established in districts to hear exclusively matters of family strict such as divorce, child custody, etc. The courts of munsifs and the courts of tiny case decide cases involving small sums underneath. No appeal may be brought against the judgment of the courts of the little case. All these tribunals hear civil disputes and resolve them. Appeals are heard not just by the district judge court, named the district courts, but some of the cases are started directly with the district judge court itself. The High Court of State may hear appeals against this court's decisions. Civil courts handle cases relating to conflicts between the two or more individuals who read properties, divorces, contracts, and contraventions of problems between landlords. Criminal courts. The Court of Sessions is the highest court for criminal trials within a district, known as the Session Court. When exercising competence in criminal issues, the district court is referred to as Court of Sessions according to the Criminal Code (CRPC). There are courts of first, second, and third class magistrates below this court. The first class magistrates are termed Metropolitan Magistrate in metropolitan cities such as Delhi, Calcutta, Mumbai, and Chennai. All of these criminal courts are responsible for the prosecution of the accused and for punishing those found guilty of a violation of law as sanctioned by the law. Any legal sentence can be imposed by the district and sessions court, but the High Court shall confirm a death penalty. An assistant judge has the power to imprison an individual for 10 years. A first-class judge may impose an imprisonment of no more than 2 years or a penalty of no more than 1,000 rupees. Criminal tribunals handle cases connected to the breaches of the law. These incidents include robbery, dacoit, rape, incense, pickpocketing, physical assault, killing, murder, etc. The culprit is punished in such circumstances. It might be jail, or even a death penalty. Every accused person is usually introduced to a magistrate by the police. Finally, the judge can dispose of lesser crimes. However, the judge might commit the accused before the session court when he or she finds a prima facie case of major criminal offense. Therefore, the courts of sessions try the defendant who is sent by the judge in question. As already mentioned, a defendant granted the death penalty by the sessions court can only be put to death if the High Court has affirmed his sentence. Revenue courts. Land income is a significant source of government income. The Revenue Board is at the height of all the courts of income. The Commission, the Court of Talisdar, and Nayab Tahsildar are within the remit of the Committee on Income. Every district's land revenue system has independent courts. Any disagreement concerning land income is brought to the Tahsildar court first. The collector or the deputy commissioner shall have an appeal against the decision. An appeal may thereafter be brought in the court against the judgment of the deputy commissioner's court. The Revenue Board, which is the highest land court in revenue cases, can be called further. Moving on to our last topic for today, judiciary in Goa. In the lengthy and beautiful judicial history of the territory, the Bombay High Court bench in Panaji opens a new chapter. The High Court of Bombay became the common High Court of Maharashtra and Goa and Union Territories for Dadra and Nagar Haveli and Daman and Diu (WEF) 30-05-1987 with the passage in Goa of the Daman and Reorganization Law 1987 by the Parliament confederating Goa statehood. Panaji bench has jurisdiction in all relation to all appeals, applications and references as well as requests for the high exercises of power in the state of Goa originating under Articles 226 and 227 of the Bombay High Court. The first Goa permanent judge was appointed by the Justice G.F. Kuto when the High Court in Goa had a bench. There are other regional benches in Maharashtra and Nagpur and Aurangabad. At Lyceum Complex, Altino Panaji is the Bombay High Court bench of Goa. Subordinate judiciary in Goa. In a district, the district and sessions court is the highest. There are 3 more districts and sessions judges under the district judge who deal with civil and criminal proceedings. A panel of government advocates is established for this purpose. The state defense officer is termed the public prosecutor in each session court. The courts at Taluka, the headquarters, are located below the district and sessions. The judicial magistrate of the first class, JMFC, is a judge who is also named the civilian judge. Every criminal tribunal on Taluka level includes a public official named Assistant Public Prosecutor APP and the civilian judges of the junior division who hear small claims suits up to lakh of rupees. The handles of a civil judge from the senior division are above 1 lakh rupee suits. In Goa also, quick track courts were began. Tiswadi, Panaji, Salset in Margao and Bardes were established in all 5 courts in Mapusa. The judges are ranked as adjudant judges of the meetings. They are designed to dispose of the backlog for a period of time of the number of cases accumulated. Mapusa is subject to an NDPS Act case courts for narcotic drugs and psychotropic substances, NDF 9. The judge is a judge of extra meetings. In addition, there are almost judicial courts in the streets such as motor vehicles courts, administrative tribunals and industrial tribunals. So children, we are done with our chapter. I hope I have made this lesson as easy as possible for all of you to understand. Now, try to answer these personal questions on your own. 1. From which source India got the concept of single order of court? 2. Who can remove the judge of Supreme Court? 3. What is the current salary of Chief Justice of the Supreme Court? 4. Who has the right to establish the bench of Supreme Court elsewhere in the country? Your time's up. Now, pay attention as I'm going to read the answers out. Question 1. Government of India Act 1935. Question 2. The proposal for the removal of the judge should be passed with a special majority in both the houses of parliament, while the decision to remove the post is taken by the president. Question 3. The salary of Chief Justice of India increased to Rs 2,80,000 per month from Rs 1 lakh earlier. Other judges of the Supreme Court will get a salary of 2.5 lakhs. The Chief Justice of the Supreme Court has rights to seek the permission of the President before setting up the Supreme Court bench elsewhere in the country is the answer for question 4. It was a great experience and I'm pretty much sure you guys feel the same. With that said, today's class comes to an end. We will meet soon in the next one. Thank you.